This presentation on judicial review and the counter-majoritarian dilemma brings many of the discussions that we've had before in class and on the presentations on Are You Connected together. And what I'm going to say regarding judicial review and the counter-majoritarian dilemma are very often for the greater part not new concepts or new ideas, but it brings together the focus and the tension that necessarily will spring from a constitutional system such as that we have in South Africa. Now, judicial review, under judicial review in a state with a supreme constitution, the task of the court is seeing to enforce the provisions of the supreme constitution. You will recall when we spoke about constitutional supremacy, we said, well, so what if you have a document that says, I am supreme? How are you going to ensure that the document is indeed adhered to? And the Latin maxim, ubi ius, ibi remedium, means where there is a right, there is a remedy. So if we create a constitution that is supreme, there must be a means of enforcing the supremacy of that constitution. Now, in the American Constitution, which is the mother of all constitutions based on this model, this constitution asserted its own supremacy, but it did not explicitly provide for the courts to enforce that supremacy. And the case of Marbury versus Madsen, which was an 1803 decision of the Supreme Court in the United States of America, the court was confronted with a issue where it had to determine whether it could enforce the supremacy of that constitution. Now the facts, and I think it's quite interesting to go through the facts. The facts of the case were that an executive officer, remember now, this is a person falling under the executive branch of the government, that person refused to fulfill his or her, that was his obviously, constitutional task because the person did not issue the commissions of the justices of peace that were duly appointed by the president and supported by the legislature. So these people who were appointed as justices of the peace were at a loss. They couldn't perform their duties because they have not received their commissions, although the president and the legislature said, it's fine, you can do it. The official tasked with the task did not do it. Now, what is the role of the court here? The Constitution conferred that authority to appoint the person on the president and provided for a check in legislative oversight. But the court then had to interpret the provisions of the Constitution to ensure compliance. So the court in this particular instance said that the framers of the Constitution surely envisioned a specific role for the courts in a system with a written supreme constitution, and it asserted for itself the right to ensure that the Constitution is complied with. So the court assumed the power of judicial review to ensure compliance with the supremacy of the Constitution. Now, you will recall from your discussion in Legal Theory 1, the theory of natural law, that there is a higher standard, and that one way or the other we have to reflect and adhere to that standard. Now, when we have a written constitution, we don't have epiphanies about what the higher standard is. The higher standard, both in substance and procedure, is set out in the Constitution. And through judicial review, that in the American context, the court asserted for itself in Marbury's case, the court has the authority, the power, to ensure compliance with constitutional provisions. Now, this stands in contrast with the system of parliamentary sovereignty, as we've discussed in the previous presentation. In Westminster parliamentary sovereignty system, authority derives from the people. It is legitimate because the people supports the legislature and therefore, by implication, supports the actions taken by the legislature. If they don't like the legislature, well, vote differently next time. Now, we said in a Westminster system, the role of the court is limited. The court may only question procedure. It may not question the substance of legislation. Thus, in a system of parliamentary sovereignty, if the if the legislature wants to make unfair legislation, single people out, repeal previous acts that would have seemed quite legitimate, then that is something with the unbridled power that the Parliament has cannot be stopped, content-wise. But if the appropriate procedure is not followed, then the courts have the authority to review that legislation and to declare it as to be non-compliant with their own prescriptions of Parliament in that regard. So the role of the judge is very different under a system of parliamentary sovereignty. And there is some discussion and tension about what is the appropriate role of a judge, irrespective of system. But generally the point of departure is that judges must speak the law and not make the law. Judices est jus dicere sed non dare. Speak the law, don't make it. But under a supreme constitution, there is far more extensive powers of review, and judges, in their pronouncements on the law, are to some extent, and we acknowledge this, but a limited extent, involved in the process of making law, because they question not only procedure, but substance for compliance with the Supreme Constitution. So judicial review is an important check. It's a power afforded to the judiciary to ensure that the Constitution reigns supreme. So judges are given a particular task to ensure the enforcement of all the obligations that are set out in the Constitution. So, and this idea of judicial review, the power of judicial review rather, flows from checks and balances that enhance the doctrine of separation of powers, as we've discussed before. But I've raised this issue with you before. Even in a system where you have a supreme constitution, where judges do have this awesome power of judicial review, how far does it extend? Is it possible for a judge to say, well, today I just actually don't feel like it, I'm not going to do it, or I want to change it, or I don't like it? So how far does this power of judicial review extend? And this is when it comes to the next important concept, the counter-majoritarian dilemma. And I want you to think very carefully about this, and that we discuss this in class quite extensively. Now, this is a result. The dilemma comes about where you have a supreme constitution. Remember now that the legislature derives its authority from the people. The executive in the American system derives its authority from the people. In a Westminster system with a parliamentary government, indirectly the executive derives its authority from the people. So that we have two elected branches, either directly or indirectly, executive, legislature. And we have the judges who are appointed. Judges are not elected. Particularly at the higher levels, judges are appointed, and they are vested with power to set aside laws made by our legitimate representatives. Judges, for the greater part, are not people who are of the people necessarily. Judges are all trained in law. Judges have been in practice for a long period of time, and they are generally seen as people who are members of the elite. Now, if we take the power that we the people have to make laws for ourselves, and we give that power to judges, and we say, well, judges, you just check whether you like this or don't like this, and tell us whether it's constitutional or not. Are we not actually relinquishing our democratic right to govern ourselves? I am overstating this point, but in order to make it. So, with constitutional supremacy, and this is what the counter-majoritarian dilemma is about, there is a tension. There is a tension that comes about as a result of the fact that an unelected, and arguably, in some people's minds, unaccountable body, the judiciary, is given significant power to overrule the will of the majority. But, as I always say, do we have to lose sleep about this? And I want to assure you that in any system of governance where you have the trias politica, in other words, the division of power between the executive, legislature and judiciary, and particularly where there is the power of extensive judicial review to question both substance and procedure, you necessarily end up with a tension between the branches. The tension between the executive and the judiciary, the tension between the legislature and the judiciary is not abnormal. It is not something that we have to be scared of. It is not something that we should try and root out. By way of the setup of our government, any government where you have the separation of powers, the tension is normal. It will necessarily come about. And if it doesn't come about, then we have to ask questions as to the independence of the judiciary in those particular polities. So does it matter? Do we have to lose sleep as a result of this dilemma? And can we deal with this tension? And I want you to think about this and bring your ideas to class so that we can discuss this. Judges, we have to remember, are trained in law. Judges are human beings, as we all are. But judges do not engage with the Constitution in an unconstrained fashion. They too are bound by the constitutional mandate. They too have circumscribed powers in terms of the Constitution. They are bound by precedent. There are constitutional interpretative methods that create a framework within which they have to operate. The Constitution is not simply what a judge wants it to mean. Please bring your questions regarding this to class tomorrow.